Losing a loved one is a profoundly difficult experience. During this heartbreaking time, the last thing your family needs is the overwhelming burden of the legal system. Yet, amidst the sorrow, families are often forced to navigate probate. This tedious, court-supervised procedure can freeze assets for months, adding unnecessary stress to a fragile situation. Today, we will guide you through actionable steps to protect your assets and help your family avoid probate entirely. Please note, this video is for informational purposes only and does not constitute legal advice. When a loved one passes away, their estate often goes through a formal legal process known as probate. Simply put, probate is the court-supervised procedure of authenticating a last will and testament. It sounds incredibly formal, and it is. The court officially appoints an executor to manage the estate, requiring a mountain of paperwork. Every asset, debt, and final wish is scrutinized under the watchful eye of a judge. The court's role in this process can be broken down into 4 distinct steps. First, validating the will. Second, identifying and inventorying all of the deceased person's assets. Third, paying off any outstanding debts and taxes. And finally, distributing the remaining assets to the rightful beneficiaries. But here is what families often do not realize until it is too late. Probate is rarely quick, easily tying up an estate for months or even years. Furthermore, everything handled in probate becomes public record, stripping away your family's financial privacy. While probate is a standard legal process, it is often something you want to spare your loved ones. First is the cost. Court costs, executor fees, and attorney fees can significantly reduce the inheritance you intend to leave behind. In fact, probate costs can easily consume 3 to 7% of your total estate value, depending on your state and asset complexity. Then come the frustrating time delays. Probate is rarely quick, often taking 9 to 18 months to settle, tying up funds when your family needs them most. Furthermore, probate is a matter of public record, meaning anyone can see your estate details. Add the sheer complexity of court filings and legal jargon, and it quickly becomes a recipe for immense stress during an already difficult grieving period. The most effective tool for bypassing probate is a revocable living trust. Think of it as a private, secure vault. You transfer ownership of your home, bank accounts, and vehicles into this trust. You remain completely in charge while alive, but when you pass away, everything inside transfers directly to your loved ones, entirely avoiding the probate court. There are 3 key roles to understand: the grantor, who creates the trust, the trustee, who manages it, and the beneficiary, who receives the assets. Typically, you act as all 3 while alive. If you become incapacitated, a backup trustee steps in seamlessly. Besides avoiding probate, a trust keeps your financial affairs private. Setting one up usually costs between $1,000 and $5,000. However, this upfront investment can save your grieving family thousands in legal fees and months of waiting. Another highly effective way to bypass probate is through joint ownership. For many married couples and trusted partners, sharing the title of an asset means it transfers automatically when one person passes away. But the type of joint ownership matters. With joint tenancy with right of survivorship, or tenancy by the entirety, the surviving owner absorbs the full asset. In contrast, tenancy in common leaves the share to separate heirs, triggering probate. Setting this up is as simple as updating your property deed. But be cautious. Adding a joint owner exposes your assets to their potential creditors or legal debts. Another highly effective yet incredibly simple way to keep assets out of probate is by using payable on death, or POD, designations. By simply adding a POD beneficiary to your checking, savings, or certificate of deposit accounts, those funds will transfer automatically upon your passing. Similarly, for your investment accounts, you can use a transfer on death, or TOD, registration. This works just like a pod, but it applies to stocks, bonds, and mutual funds held in brokerage accounts, ensuring your portfolio transitions smoothly. The biggest advantage of both POD and TOD designations is their direct nature. the assets flow immediately to your named beneficiaries, completely bypassing the lengthy, public, and costly probate court process. If you are managing a smaller estate, there is a streamlined solution. Many states offer simplified procedures designed to save time and money. Instead of facing a mountain of legal documents, you can handle asset transfers efficiently. Eligibility depends on your state's specific threshold. For example, California considers estates under $166,250 as small. If eligible, you can often bypass full probate by simply filing a small estate affidavit. Strategy number 5, gifting your assets. A simple way to bypass probate is to give assets away during your lifetime. By gifting to loved ones now, you steadily reduce the overall size of your estate. In 2024, you can gift up to $18,000 per recipient annually without tax penalties, alongside a $13.61 million lifetime exemption. Always consult a tax advisor to understand the full implications before transferring wealth. Strategy 6 is utilizing beneficiary designations. For specific assets like a 401k, IRA, or life insurance policy, you can name a beneficiary directly on the account, allowing these funds to bypass probate entirely. However, setting it up is only the first step. You must review these designations regularly. Make it a habit to check them annually or after any major life event, like a marriage or the birth of a child, ensuring they always align with your current wishes. While individual strategies to avoid probate are highly effective, they are just pieces of a larger puzzle. To truly protect your family's future and preserve your legacy, you need a cohesive, comprehensive estate plan. Picture a complete estate plan as a central hub. It seamlessly interconnects essential tools like your will, trust, power of attorney, and healthcare directive. Remember, even if you successfully bypass probate with other methods, having a foundational will remains vital. It provides clear guidance for your grieving family and catches any overlooked assets. Because estate laws vary widely by state, and every family situation is entirely unique, it is strongly recommended to consult an experienced estate planning attorney. They will ensure your plan is legally watertight, giving your family true peace of mind when they need it most. To recap, avoiding probate involves a few key strategies. Set up a living trust to bypass court, use joint ownership for property, and assign payable-on-death beneficiaries for your financial accounts. We are often asked, what happens if I die without a will? This is called dying intestate. Your state's laws will dictate who receives your assets, and your family is guaranteed to face the probate process. Taking action now protects your loved ones from unnecessary stress during a difficult time. For more resources and to find local support, visit funeralas.com today. Thank you for joining us on this important discussion about navigating probate and planning for your family's future. We hope this guide has brought you clarity and peace of mind. If you found this information helpful, please give this video a like, subscribe to our channel for more valuable content, and share your thoughts or questions in the comments below. Take care.